Over recent years, prenuptial agreements have become much more common in England and Wales. Many people seek the clarity and security that can be provided by a prenuptial agreement. They seek to protect assets such as properties already owned, inherited wealth, or family or personal businesses. Prenuptial agreements can provide this clarity and security, albeit as yet not with any certainty. The sea change in England and Wales happened in 2010 with the Supreme Court case of Radmacher and Granite Eno. Prior to this case, prenuptial agreements had generally speaking not been taken into account in England and Wales. The court in Radmacher and Granite Eno set out a fairly simple test as to when a prenuptial agreement would be taken into account and the extent to which it would be taken into account. The court said that it would consider a prenuptial agreement that was freely entered into by both parties with a full appreciation as to its implications, as long as it was fair to do so. In other words, if the agreement is fair and if both parties fully understand the terms of the agreement, then the court would consider it. So, looking at the cases since then, the subsequent cases and also the Law Commission's report, the indications are that if both parties have had independent legal advice, if both parties have fully and frankly disclosed their financial position to the other in advance of signing the agreement, and, importantly, if the agreement is signed at least 28 days in advance of any marriage, then the agreement is likely to be considered by the court. You'll note that I say will be considered by the court rather than will be upheld by the court. The court has to take into account a number of different factors when determining a division of matrimonial finances upon separation. The most important of these is always the needs of any children of the family. Following that, the court will almost invariably take into account the needs of the two spouses, bearing in mind other factors such as contributions, the length of the marriage, and the standard of living during the marriage. The prenuptial agreement will be one of those factors, if it is considered fair by the court, bearing in mind those factors that I discussed previously. If in the court's view the prenuptial agreement does not meet the needs of either the children of the family or of either of the spouses, then it's very unlikely that the prenuptial agreement will be upheld, although it may still have an impact. So the current position is that a court will take into account a prenuptial agreement if it is considered fair, if it has been freely entered into, if both parties have had independent legal advice and are fully aware of the financial circumstances of the other spouse, and there has been no fraud, misrepresentation or undue influence. Part of that includes the agreement being signed at least 28 days in advance of any marriage. And remember as well that the agreement will be subject to the needs of any children of the family and to the needs of the spouses at the time of separation. So, is a prenuptial agreement for you? Prenuptial agreements can be very persuasive in protecting property acquired prior to the marriage, inherited wealth, family businesses, personal businesses, and any other assets that are sought to be protected by the agreement. The agreement also provides security to both parties in that, to a large extent, you know where you stand if there is to be a separation. The agreement can also protect in relation to the difficult atmosphere of a separation. If agreement has already been reached regarding how the assets are to be divided, then a lot of the emotional difficulties and a lot of the expense associated with divorce can be avoided in many circumstances. So prenuptial agreements are worth considering. They can provide the clarity and security that is missing in so many divorces that are currently ongoing. If you are considering a prenuptial agreement, or indeed a postnuptial agreement, then Osborne's family law specialists have detailed experience in relation to drafting and advising on these agreements, from the most simple agreements protecting a property to detailed inheritance, business and trust assets and agreements. If you have any further questions or wish to make an appointment regarding a prenuptial agreement or a postnuptial agreement, then please contact one of Osborne's family law specialists.